In Missouri, professionals who work with children carry an immediate legal obligation to report suspected abuse or neglect. Failing to make this report is a crime that can result in jail time, fines, and the loss of your professional license. Abuse and neglect are seldom obvious right away. The signs usually start small: a sudden behavioral change, an unexplained physical mark, or a concerning comment. Because these markers can be subtle, the system is designed for intervention long before a full investigation is completed. To ensure early intervention, Missouri law uses a specific threshold: reasonable cause to suspect. You do not need proof. You are not an investigator, and you do not need to interrogate the child. The law protects you so you can act on a disclosure or an observation without first having to secure concrete evidence. Your primary function is to serve as the initial alert. When you identify a warning sign, you notify the authorities so that the Children's Division or law enforcement can begin their mandated assessment. Step 1 begins the moment reasonable cause is triggered. Before you approach the family or alert anyone suspected of harm, you must consolidate the information you currently have. This checklist shows the specific data points the state requires. You need the names and addresses of both the child and their parents. You must describe the nature and extent of the injuries or neglect, and if you know it, provide the name of the person suspected to be responsible. Under Missouri law, the duty to report is individual and non-delegable. You cannot pass this task to a manager, and no supervisor, principal, or administrator is legally permitted to block or delay your report. If you are missing an address or a last name, do not wait to find it. If a child is in active danger, file the report immediately with the information you have available. The accuracy of the data you provide in those first few minutes determines how quickly the state can locate the child and begin their assessment. Once your information is gathered, you must select how to submit it. Missouri maintains 2 separate channels for mandated reporters to contact the Children's Division. Your primary pathway for immediate dispatch is the state hotline at 1-800-392-3738, staffed 24/7. The secondary pathway is the online reporting portal at dss.mo.gov for non-emergencies. There are specific high-risk scenarios where the online portal is strictly forbidden. You must call the hotline directly if a child is suicidal, if there is exposure to a methamphetamine lab, or if you suspect sexual abuse and the perpetrator has immediate access to the child. Regardless of which channel you use, the state will issue a confirmation. On the phone, the hotline worker will provide a confirmation number. Online, the system generates one automatically. Using the non-emergency web portal for a high-risk situation can cause a delay in getting a caseworker or an officer to the child. Procedurally, your job is not done once the report is submitted. You must now transition into documenting your actions. Your log should include the date and time of the report, the confirmation number you were given, the name of the worker you spoke with, and any actions they indicated would be taken. This creates a time-stamped record of the report. This log serves as your evidence that the state was notified, fulfilling your statutory requirements. These notes are the specific documentation you will need to initiate an escalation if the Children's Division fails to respond within the legal timeframe. Missouri law requires the Children's Division to initiate an investigation within 24 hours. If that window closes and the system has not responded, you must move to the escalation phase. This staircase outlines your escalation options. Your first step is to re-report to the hotline. Use your original confirmation number to link the files. Providing new details creates a fresh institutional record that the state must address. If the situation remains unaddressed, you can contact local law enforcement or the juvenile office. This triggers a parallel investigation that operates independently of the Children's Division. For cases that remain stalled, you can contact the Office of Child Advocate, or OCA. This independent oversight body is separate from the Department of Social Services. Contacting them initiates an external review of the Children's Division's inaction, auditing whether the agency followed the law. Do not assume that a single unanswered hotline call ends your responsibility. If a child remains in danger and the system has not moved, the duty to act persists. Utilizing these escalation paths ensures that a bureaucratic delay does not become a permanent barrier to the child's safety. By following these steps and documenting each one, you satisfy your legal mandate and ensure you have used the tools the law provides. Your final step is to secure your records. Because these documents contain sensitive information about a child and family, they must be physically or digitally locked to maintain confidentiality. Set a calendar reminder for 24 hours after your report. Use this as a final checkpoint to verify that the state has initiated its intervention. By maintaining meticulous records and knowing how to navigate the escalation channels, you ensure that you have fulfilled your legal duty and provided the oversight necessary to help a child get the protection they need.